In this class, we'll discuss about trademarks, which is also a part falling under intellectual property rights. So, regarding trademarks, we framed six important questions which are exclusively important in the context of Trademarks Act 1999. So, the first question relating to trademarks is discuss the role of trademark and its usefulness in marketing. So, in relation to that, every day each of us use many trademarks either in shops, supermarkets, restaurants, televisions, or newspapers. Some of the famous trademark products have become a part of our daily life. Trademarks create unforgettable impression in the minds of customers, leading to the differentiation in product personality. It helps to mold the trade dress of an enterprise and links customers' brand preference to the specific company. The corporate identity is sometimes linked with strong trademark. It is used as product differentiator. It speaks about the product's origin and its quality. It is a valuable marketing tool in today's competitive markets. It has a legal protection to keep others away from using it. The good trademarks are associated with quality, security, and even sense of belonging in the minds of the consumers for that product. Few trademarks like those of Tata, Godrej, Parles, Reliance, etc. embodied the goodwill of the company and institution they represent. In a sense, trademark is a legally protected, valuable marketing tool for product differentiation. Trademarks require a dedicated team effort and preventive maintenance on the part of its owner to protect its value, since there is no road back once a trademark is lost. The trademarks convey to us the important information on the source and quality of the product. Trademarks are one of the important marketing tools and the foundation of competition for businesses. Presence of a lot of trademarks in the market also signifies the freedom of choice to consumers. Trademarks are being used for a long time. Some have been found on the pottery that we found in Indus Valley civilization, also in China. So the pottery made around 5000 before crest that we found those potteries of Indus Valley and also in China. Trademarks were used for different reasons in different parts of the world. Also, we found the Egyptian and Roman bricks. Egyptian and Roman masons marked as their bricks for the purpose of accountability in case the building collapsed. So, in 1266, the English bakers. So, in 1266 in England, a law was passed requiring bakers to mark their bread so that if any bread be faulty in weight, it may be then known that who is at fault. And in the same way, the Boston sailcloth makers in 1791 petitioned USA Congress to be allowed to register their marks. The matter was referred to Thomas Jefferson, the then Secretary of State, who decided that it would be, in his opinion, contribute to fidelity in the execution of manufacturing to secure every manufacturer an exclusive right to some mark on its ware proper to itself. So, in 1870, the first USA trademark law was enacted by the Congress. It was later declared unconstitutional because it was improperly based on the patent and copyright clause in the Constitution. It was not until 1881 that a new law based upon the Commerce Clause was passed. So, once a trademark is registered, it can be renewed indefinitely, provided it is still being used to commerce. However, the owner must prevent the public from misusing the brand name to refer to all similar products. This is done by reminding the public through advertising that their brand names are trademarks and not just words. So, in that connection, we'll discuss certain examples, such as in the past, some trademarks owners were unable to protect their marks after the public adopted them as common product names such as cornflakes, dry ice, aspirin, kerosene, etc. When the symbol is put near the mark on the product, it means that the trademark or service mark is registered with the Patent and Trademark Office of the country. So, in relation to that, we will discuss one important leading case, and that is relating to Jet Airways. So, in that connection, we'll discuss that in today's competitive markets, the importance of trademark as an intellectual property cannot be ignored. It is a valuable intellectual property asset. A registered trademark gives the legal right to use, license to sell it within the territory, country, or region for the goods and services for which it is registered. Sometimes, over the period of time, a trademark usually becomes synonymous with goods such as cartridge for store well and xerox for photocopying. The trademark rights can also be the can also be sold to other parties. As Jet Airways, India's largest airlines, brought back its trademark from Jet Enterprises, a company owned by its promoter, for a one-time fee of $7 million. And now we'll go to another leading case relating to this question, and that is the Poirot versus Julius Poirot in 1920 under the principle of residual renown, where a trader ceases to carry on business he may nevertheless retain for some period the goodwill attached to the business. In case of Poirot versus Julius Poirot in 1920, the court held that where the trader intends to resume business, he may still retain the goodwill. So, in the important case relating to Budweiser case of 1984, that relating to the versus Budweiser versus Miller and Company, the court held that goodwill has no independent existence and it cannot subsist by itself without business. However, several courts have taken different views on the subject. For example, the trademark taken as 7 o'clock of Gillette and was used by the defendants in India for toothbrushes, despite the fact that Gillette had suspended business in the country. The court held that suspension of business does not destroy the reputation or goodwill. This has been the consistent view taken by several courts. A trademark can be a word, phrase, letter, number, sound, smell, shape, logo, picture, aspects of packaging, or a combination of these. It is used to distinguish the goods and services of one trader or manufacturer from those of another. So the difference between trademark, business, establishment, and the domain name sometimes lead to confusion for both the traders and the consumers. A company name is registered with the Register of Companies, a government body formed under the Companies Act 1957. So, the business name is a name under which a business operates. Registration serves a means of identifying the owners of the business and is obtained under state or local legislation body as under Bombay Establishment Act of 1947. And in relation to this very question, we'll discuss one important leading case, and that is one of the most important leading case in the world. It is the Yahoo case. So, in the Yahoo case, the plaintiff Yahoo Inc. United States of America is the owner of the trademark Yahoo and domain name yahoo.com, registered with Network Solution Inc., United States of America since January 18, 1995, on discovering that the defendants, Akash Arora and others, had adopted deceptively similar domain name yahoo.india.com for internet related services, filed the suit using the seeking domain name yahooindia.com or any other marked domain name identical or deceptively similar to the plaintiff's trademarks Yahoo in trade on the internet, granting interim relief as sought. The court further restrained the defendants from copying the contents of the programs under the plaintiff's domain name yahoo.com. So, the very question is that was that discuss the role of trademark and its usefulness in marketing. And regarding this very question, we in precisely discuss the very relevant answer relating to this question as we discuss regarding the very meaning of trademark and also certain traditional examples of use of trademarks, just as regarding the pottery of Indus Valley civilization in China, where it was used as certain symbols 5,000 years ago. So also the Egyptian and Roman masons, as they use symbols in their bricks, so also the England bakers in 1266, and as regarding the Boston sailcloth makers in 1791 in United States of America, and as the first USA trademark law was enacted in 1770, and also certain important leading cases or problems just as yet Airways and Jet Enterprises in 2005, then Pirate versus Julius Pirate in 1920, then the Budweiser case of 1984 against the Millers and Company, also the 7 o'clock case of Gillette Company, and the Companies Act, under which how companies are registered with the certain trademarks and symbols in 1957, and the Bombay Establishment Act of 1947 as a local act dealing with the very legislative body to obtain business in a local area. And lastly, the very important leading case, that is Yahoo case. So, in our second question, we will discuss what are trademark rights, how are they registered, in our upcoming video.